Okay, hello folks. I make it the second Wednesday of the month. I make it 2 o'clock. That means hashtag webinar Wednesdays. I can see a good number of you have logged on to join us this afternoon, and welcome. This afternoon's session, as you can see on screen there, is our employment law update. We are joined by Zena Rowe, one of the solicitors at Invicta Law, and she's going to take us through an employment law update this afternoon. So welcome, Zena.
Hello.
And in particular, we're going to be focusing on tribunal fees, suspension. There's been some interesting updates there, data protection and the new GDPR regulations. We're going to look at unfair dismissal and also some interesting things in the world of Ofsted. So lots of things for us to talk about this afternoon. Hopefully folks are familiar with our webinar toolbar there that you'll be able to see on screen. We do this afternoon have a couple of resources there that you might find interesting to look at. We've got a copy of this afternoon's presentation because there's quite a bit of detail, so we thought that would be useful for you to be able to take away, as well as some information from our friends at Invicta Law. So do have a look at that. You can download it at your convenience and you'll be able to have a look at those. So let's get started and have a look in a little bit more detail about what we're going to be covering. So employment tribunal fees, hopefully it hasn't escaped people's notice that employment tribunal fees, there's been some changes there, and the fees are being withdrawn, and Zena's going to talk to us about what does that mean for us as employers, what do we need to be thinking about. Going to be having a look at suspension, whether that's a neutral act or a breach of contract, and there's been some interesting sort of case law and updates around that very issue. We want to make sure that you're as ready as possible for the data protection bill and the new GDPR regulations. Just on that note, we're going to give you a bit of an outline this afternoon. In terms of more detailed training, SPS partnered with experts from information governance, a lady called Michelle Hunt. We are meeting later this month to look at putting together some training for you for schools. The reason that we have looked to do that into the autumn, I know other providers have already started that work, but the reason we're looking at that later in the autumn is because the final practice guidance hasn't been published yet. So we took a view that we wanted to make sure that we had all the necessary information, both legislative and practice guidance available, so that we could then be sharing that with you and giving you the very latest information and ensuring that our training was absolutely sort of fit for purpose and going to help you on a very practical basis to work in line with the bill and to be compliant with the regs that are coming on board. So we are on it. We will be issuing some training or making training available shortly. So please do keep an eye on our website, our SPS newsletter, for more information. Okay, back to this afternoon. So unfair dismissal compensatory cap. Going to look at whether this includes pension contributions and some of the issues that relate to that. And also Ofsted, as I mentioned, are they too good to be challenged? Well, there's been an interesting case that's going to give an answer to that question, and it might well shock you. So those are the topics that we've picked for this afternoon. The sort of usual items of national minimum wage, etc. There haven't been any changes this October, this sort of employment law cycle. So these are the topics that we thought would be of interest to you. And Zena, you're going to start us off with employment tribunal fees.
Yes, hello everyone. Thanks for joining us. So so as Summer rightly pointed out, the tribunal fees have now gone. So on 26th of July, the Supreme Court handed down its judgment with the case that Unison brought to challenge the fee order regime, and the Supreme Court has ruled the fee scheme to be unlawful because it prevented access to justice. So the entire fee order has been quashed with immediate effect from the 26th of July. So employment tribunals have not been taking any fees for any claims since then. So what does that really mean for us now? So as an employment lawyer, when the fee scheme was introduced, it made a huge difference to claims that were coming through my office and everyone else's offices, and the litigation in that respect in terms of claims literally fell off a cliff. So with the elimination of the fee regime, most commentators and professionals are expecting a rise in claims over the next year or so, and then for the foreseeable future. Also, in addition to that, judges have also made some arguments about, or rather acknowledged some arguments that have been put forward by claimants who were prevented from making a claim, either because they couldn't pay the fees at the time, or they didn't make a claim or they didn't pay the fees in time, or they didn't make a claim at all because they couldn't afford to make the claim. So the judges now acknowledge the argument that time which would have otherwise run out should now be extended because of any inability to pay the fee. So obviously you understand there's time limits that are involved with making claims, but there may be a reason for the tribunal would accept for a failure to put a claim in time would be because of an inability to pay the fee. So we may start to see retrospective claims being made on that basis, and also the reinstatement of cases which were struck out for the non-payment of fees at the time. So just a warning there, really, that perhaps that's something you need to put your mind to, and in it for the future. So, and also just some interesting stats that I thought we could have a look at, not to scaremonger everyone too much, but it's good to keep an eye on these things and have a look at that. So in April 2016 to March 2017, a total of 88,476 claims were accepted by the employment tribunals, compared with a total of 191,451 claims received in 2012 to 2013, that being the last complete year before the introduction of the fee scheme. So that's the stats speak for themselves there, and how the huge effect that the fee scheme did have on preventing claims being brought through the tribunals. So the largest award made in unfair dismissal claim last year was a staggering £1,744,575.56. So that's a huge claim. That's obviously not a usual claim. That's a hugely lucky high earner that's been able to push that claim through the employment tribunal. So the more normal claims that you might look at, obviously the average award for unfair dismissal was 16,553, which is a drop from the last year's, and the median award was 7,521. So I mean, they're your usual claims that you'd be looking at, really. And the largest award made in discrimination claim was 456,434. So, and also this last statistic here, this is really quite an interesting statistic, that claimants were represented by lawyers in respect of 86% of claims last year, which is an increase of 84% on the year before that. So there may be some reasons for that, maybe that that would cause that skew in the statistics, that perhaps there are more class actions, so that's when you get a large volume of claimants bringing a claim all at once, and they obviously would have been legally represented, and perhaps that skewed the statistics. Or it could be more and more claimants are successfully obtaining legal advice and representation, which at an early stage, which means it's more likely they're going to see the claim through to a hearing once they've forked out some fees on for their lawyers. So just of interest there, really, just to keep that in your mind. So so the next topic that we were going to look at is that Summer introduced earlier, is about suspension, and about whether or not, when you do suspend somebody, is that always considered to be a neutral act, or can it sometimes amount to a breach of contract? So there's been a recent case where the question was posed, did suspension of a teacher amount to a breach of the implied term of mutual trust and confidence? So just to recap, in case you're not all familiar what the term of mutual trust and confidence is, so that's an implied term into all employment contracts, which is an obligation on both parties not to do anything without reasonable and proper cause to seriously calculate or seriously destroy the relationship between the relationship of trust and confidence between the employee and the employer. So the answer to that question, actually, in this particular case, was yes. So a teacher was suspended, and suspended in such a way that it did amount to a breach of her employment contract. So this case was held in the High Court of Zagario and London Borough of Lambeth. So in this case, Mrs. Zagario, the claimant, was employed as a primary school teacher by the London Borough of Lambeth from 9th of November to 2012. She had around 15 years teaching experience, and as part of her role was required to teach a class of up to 29 5- and 6-year-old children. 2 of those children exhibited extremely challenging behaviour, and the claimant had made numerous requests to the school where she worked for additional support in relation to these 2 particular children. This was eventually acknowledged by the school, which started to put in place appropriate supportive measures for the teacher. But 5 weeks into her employment, the claimant was suspended from work following allegations that she had used unreasonable force towards the 2 children referred to by her to the school on 3 occasions. So the claimant was informed that the purpose, so she was suspended and told by the school that the purpose of the suspension was to allow the investigation to be conducted fairly. So I'm sure you've all got disciplinary policies that probably reel off different reasons for why you suspend somebody, and you have to make sure that is the reason why you're suspending somebody. So on this particular occasion, that's the reason they relied on, was to allow the investigation to be conducted fairly, and wrote in a letter to her, which I'm sure many employers have done before, is to remind the employee that suspension is a neutral act and it doesn't form any disciplinary sanction or doesn't amount to any disciplinary action. So that's what happened here. But however, prior to the decision to suspend, the claimant was not asked for her comments on the allegations, nor did the employer provide any evidence to suggest that they had considered any other alternatives to suspension. And later that day, in a response to her suspension, she resigned. She subsequently brought a claim against Lambeth in the county court for breach of contract and argued that the suspension was not reasonable or necessary in order for the investigation to take place. The county court held in favour of Lambeth and said that they were bound to suspend the claimant after receiving the reports and the substance of the allegations against her. That was basically manhandling 2 children or using unnecessary force against 2 children in the classroom. But the claimant appealed to the High Court, and the High Court allowed her appeal and found that it was indeed a breach of contract. And this is also following 2 previous cases, which you may be aware of, where of Meze and Goge, that suspension was not a neutral act, at least in the context of a qualified professional in a vocation such as a teacher. Taking into account the statutory guidance for local authorities, it was noted that a knee-jerk reaction must be avoided and that suspension must not be the default position. The reason given for the suspension, as I mentioned earlier, was this is what the court held, was not the protection of the children, but to allow the investigation to be conducted fairly. So when in court they tried to change their minds and say, well, no, we needed to suspend her for the protection of the children. But this wasn't what they put in the letter. In the letter, it said the reason for your suspension is to allow the investigation to be conducted fairly. So that's all that the court needs to look at as to whether or not that was the true reason for the suspension. So the court concluded that suspension was adopted as a default position. It was a knee-jerk reaction to the allegations made out and amounted to a repudiatory breach of contract, and that was not undermined by the teacher's resignation. So the court went on to hold there had been very strong reasons on the evidence of finding that the school had been in repudiatory breach of contract. So repudiatory breach of contract just means where there's been a breach of contract that's so bad that it would entitle, it goes to the root of the contract and would entitle the teacher to resign without giving notice, which was her constructive dismissal claim. So and that her resignation did amount to a constructive dismissal. So in particular, what the court found was the suspension itself, against the backgrounds of the facts of the case, would have been sufficient to breach the implied term of mutual trust and confidence, particularly when the claimant's line manager had investigated at least 2 of the incidents previously, so the incidents of handling the children that made out the allegations, and had not considered them worthy of any disciplinary action. So this is a takeaway for this is always risky to act on or discipline an employee for something that you've previously disregarded. So the other point that the court found of note, well, it could be said that suspension within a few days of being told finally, after several weeks of requests for help from the teacher and the introduction of a scheme of support and further introduction because of problems with the children concerned, had been a further reason for that term having been broken, particularly when that proposed scheme had not yet been fully implemented. So the teacher had asked for help, help's on its way, but they haven't allowed the teacher to stay in the classroom and see how she would have got on with that help. So that was a point of consideration for the court. And also, prior to the suspension, the claimant had not been asked for her response to the allegations. So again, that's always a no-brainer. You should always, although it's not legal requirement to hold an investigation meeting, but you should always ask someone what their view is on the allegations, just to know that you have done that, and it would form part of a reasonable process. Also, there was no evidence that consideration was given to any alternative to suspension before the decision to suspend was taken. So that's always a consideration. Suspension should really be considered as a last resort, not as the tribunal, as the court's pointed out here, of just the default position. If you really need to look at whether or not it's necessary to suspend before you take that decision. So, and they did, as I've said before, suspension, they did find was adopted as a default position and largely a knee-jerk reaction just to the reporting of the incidents. And this is definitely something I've seen hundreds of times, where schools have allegations that are, on the face of it, very serious, and their first action is to suspend the teacher, the employee, who, the cleaner, whoever that might be. But that's always advised against. Certainly that's but even before this case nailed this down, would be the advice that I would give, and certainly I know my colleagues would give. It should never be a default position. So you've always got to have a reason to suspend, and that reason has to be justified. Otherwise, it's always potentially a breach of contract. And also, in terms of the education sector, particularly, breach of contract claims in the High Court are increasing, and often combined with applications for injunctive relief to restrain disciplinary action taking place, including dismissal. And I certainly personally have dealt with a few of these in the last 2 years, whereas previously there hasn't been any that have come through my office. And just a note here, the High Court was particularly influenced by the potential stigma associated with suspending a qualified professional, such as in the claimant's case, a teacher, and the potential impact that would have on her future career. So it is not to say that you shouldn't apply, obviously, the same fair process to any employee that you've got, but it's even more important when someone does hold a professional qualification, such as a teacher. I would say it's probably even more significant when a head teacher is involved and you're looking to perhaps manage an exit of a head teacher. So what can you do to reduce your exposure to such a claim? So I've touched on a few of these. So when care must always be taken when considering suspending an employee, even in cases where the alleged conduct is very serious. Suspension should not be a default position or a knee-jerk reaction. You need to follow a proper procedure when looking to suspend, particularly where the employee in question is a qualified professional. And certainly in my experience, there's a lot of head teachers that have brought this sort of action have the salaries to back up the legal fees to take it through the courts. Also, so just some procedural points here. You need to look at, do you actually have a contractual right to suspend? If you don't, you might want to think about amending your policy on that. And before you suspend, have a look at your policy. What does it say that you need to do? If you've got a list of reasons for suspension, then it needs to be one of those, and it needs to be the appropriate and true reason. Speak to the individual prior to suspension and ask for their comments on the allegations against them before taking the decision to suspend. And as this case shows, you need to carefully consider what the true purpose of the suspension would be. So what are you actually scared of? Why does this person not need to be in the workplace? And if you can't really justify removing that person from the workplace, then you shouldn't be suspending that person. So again, you need to make a paper trail to consider whether there are any alternatives to suspension, such as reassignment, and again, whether suspension is necessary, and fully document the reasons for suspension in writing. So just to close that one off, in a nutshell, you must be able to show that you have a reasonable and proper cause to suspend the employee, and on the grounds that you've relied upon. So, for example, will the employee really impede an investigation? Do they really need to be off site for you to carry out a fair investigation? Are there really actual health and safety concerns, or are they being exaggerated for you to justify that suspension?
Yeah, and I think it's really important for those of you that work with SPS. Obviously, we're there to support you. Your HR consultants are there to support you.
Yeah, exactly. And you should be taking advice before you just to have that sanity check. Take advice, and then you can just put your best foot forward then and know whether or not suspension is necessary, and not make any mistakes.
In terms of best foot forward, let's have a look at the data protection bill, and obviously thinking about that coming in to effect. So talk us through what that looks like, some headlines, Zena.
Okay, so we probably had some bump through in your email box about the data protection bill and the GDPR. So I'm just going to take you through that. I mean, as best I can. There's not all of the guidance and practice notes have come out about this yet, because it doesn't come into force until the 25th of May 2018. But there are some steps that we can take you through that might make that transition easier when that time comes around. So just a bit of background. On 15th December 2015, the EU institutions reached agreement on the General Data Protection Regulations, which will replace the Data Protection Directive. And the Data Protection Directive is where we get our Data Protection Act. So the General Data Protection Regulations will now form the UK Data Protection Bill, which was published in August 2017, which will bring the General Data Protection Regulations into UK law and establish the UK's position on data law post-Brexit. So for anyone who was hoping that we were going to get out of all of this on Brexit, unfortunately we're not. We're stuck with it, and it's going to take effect. So what's the GDPR all about? So it's fundamentally similar to the DPA in terms that it applies to the processing of personal data wholly or partly by automated means, and to the processing other than by automated means of personal data which form part of a filing system or are intended to form part of a filing system. However, unlike the DPA, the content of the GDPR is huge, and there are over 170 recitals and 99 articles, and it introduces a raft of changes for employers and schools and academies alike to get to grips with. So the GDPR makes I've just listed a few of the main requirements that are a change away from the DPA. So consent. So one, consent will need to be explicit, and you must have a legal basis for processing the data. Sensitive personal data such as ethnicity, religion, teacher union membership, medical information, sexual orientation will require additional protection. Legally, a school will be required to notify the ICO of any data protection breach. That's the Information Commissioner's Office. The scope of the term personal data has been expanded, so it now defined as information relating to it's now defined as any information relating to an identified or identifiable natural person. There will be heavier fines, for the data protection breaches, with 2 specified tiers of at least 8.5 million or 17 million. And in addition to this, individuals are now able to bring compensation claims for data protection breaches up through the courts as well. This may be of particular significance of schools in terms of the potential breaches, hazards for parents making claims against schools, so you need to watch that space. Third-party suppliers that process data for a school, such as a parent payment platforms, will be jointly responsible for protecting that data, and every school must be able to prove compliance to the new regulations by keeping records of processing activities, training, any breaches, and impact assessments.
So just talk us through, what does this mean for schools?
It's post a particular, schools have always had a particular problem, I think, we're dealing with sensitive personal data, because there is so much of it for a school and for academies alike, where you've got data on ethnicity, religion, union membership of all the teachers, medical information, special education needs and disability, looked after children, assistance, bursary recipients, and sexual orientation are all classed as sensitive material. So that there's extra pressures on a school there, because they've got more sensitive data than probably most employers do. Also, Ofsted are hot on data protection breaches and quick to criticise schools for data protection breaches. So they're more likely to be jumping on this and seeing after May 2018 that schools have made the transition and they are up and ready to comply with the regulations. Also, parents are becoming increasingly more privacy literate, and they will expect schools to be vigilant. Parents want their children looked after. I think that's what all teachers and obviously all schools want, and parents will be expecting schools to be compliant with the GDPR. So a school also must have an operational need and or explicit consent to process this data, otherwise it is a contravention that would have applied to the DPA, and also going forward that's still the same thing. But schools really aren't doing that badly. So in the second half of last year, there was only 40 data security incidents reported from the education sector to the ICO. So that's really not bad, considering how many schools there are, and academies, etc. And I think that would also probably include universities too. So, however, things are about to get a whole lot tougher, and staff need to be trained to deal with the demands coming up from the GDPR.
Yeah, and obviously, as I've already said, I mentioned at the introduction, I know a couple of people have joined us through the course of this webinar. SPS, in partnership with some information governance experts, we are going to be putting some training together and making that available to our schools and academies. The reason that we haven't done that to date, as Zena has just updated, the regulations, we are aware of what's coming into effect. What hasn't been been finalised yet, or at least released, is what the final practice guidance and requirements are going to be. So I know lots of other providers are out there offering you GDPR training. We've decided to take a view that until that final guidance is issued, is released, that we're certainly looking to await that, so that we can make sure that we are giving you absolutely the most up-to-date, current information to support you in this area of work. But just to give you some initial tips on how you can start to prepare, Zena.
Yeah, okay, so I put my mind to this and just put down a few pointers for you here. So first thing really is to appoint someone to be responsible for data protection if you haven't done so already. So as someone said, the final guidelines haven't come out, but most people are assuming that schools will be required to appoint what's called a data protection officer. Because in the GDPR it says any public body or authority is required to appoint a data protection officer. So it's assumed by most that schools and academies will fall under that definition. So also you can start documenting what personal information you've got already. Start making a log, see what you've got, and that will feed into your data mapping, which you will be required to do. So you ask your questions of all the personal information you have. Where did it come from? Where does it go? Where is it stored? And you'll be able to start mapping out the trail of data, which is important and which you will be required to do to comply with the regulations. Review all your policies and procedures and make sure they're up to date. Again, once the final guidelines have come out, that's something that SPS is going to be able to help you with, and give a check over your policies and procedures and make sure they are compliant. Also, update your procedures for dealing with subject data access requests. There's been a couple of changes here where there no longer will a charge be required, and also it's not 40 days anymore. It will be reduced to a calendar month for your response to a data subject access request. Also, where data are held or processed on the school's behalf by a third party, you need to ensure that you've got all the contact addresses and data protection, as the school and the third party will now have joint responsibility. Ensure your school has explicit opt-in consent where consent is needed, and this should make things easier going forward. Stop collecting any data that you don't need. That's quite a usual breach, an easy mistake to make, but also an avoidable mistake to make. So where you've got either holding information that you don't actually need, so there's no purpose for you to have that information, so that's potentially a breach. And also start removing duplication of information wherever possible. You could also start centralising as much data as you can into purpose-built systems such as school management information systems, so you've got a better hold on where that information is and where it's stored, where it's come from, where it's going. And you could also set up sort of trackers for obviously to delete information by a certain date. So let your systems do the work for you as much as they possibly can. If you've paid for these systems, you might as well put them to use and make your job a bit easier where you can.
Yeah, absolutely. Thanks for that. Just on point 6 there, as you can see it on screen, it also occurs to me for you to think about procurement activities or commissioning rather, and where organisations are tendering to undertake works with you. I'm thinking particularly of sort of small independent providers that are going to be working with your children. I'm thinking particularly if you've got sort of self-employed coaches and maybe therapists that are going to be working with your school, to really make sure that those tendering arrangements, that you really are testing their approach to data protection and more specifically GDPR. So whilst those third parties have joint responsibility, I think it's still important that you hold those partnerships, those contracts to sort of account, and that they're actively they're required to actively demonstrate to you how they are equally intending on complying with these guidelines. So I think that's something important for you to think about.
Yeah, because if you've done that, then at least that may go some way to sort of mitigating any, if you were found to be in breach of any data protection, then if you've taken reasonable steps to prevent that breach in respect of your contact that you have with third parties and how you structure those relationships, and that may go some way to reducing some compensation if there was a breach found there. So yeah, that's a valid point.
On the note of compensation, or rather what we're going to move on to is the compensatory cap with unfair dismissal cases. So that moves us on quite nicely, Zena.
Yeah, so there has been a recent case on this which I thought was of particular interest to schools and public bodies, public authorities alike. So usually unfair dismissal compensatory cap, it has not included, it's been usually the established line for the employment tribunals is not to include pension contributions in the compensatory cap for unfair dismissal. So sure, you're all aware now that there is a statutory cap on unfair dismissal compensation, which currently is a maximum of £80,541 or 52 weeks pay, whichever is the lowest. So in the case of University of Sunderland and Drosso, might not be pronouncing that correctly, so apologies for that. In this judgment, the EAT, so that's the Employment Appeal Tribunal, held that for the purposes of calculating the upper limit of a compensatory award for unfair dismissal, the amount of a week's pay, so that's the figure which is multiplied by 52 to obtain the maximum, and it has a statutory definition, a week's pay that has a statutory definition. So is the amount of remuneration payable under the contract of employment, which can include pension contributions paid by the employer to a pension fund. So the maximum unfair dismissal compensatory award, as I've said, is equal to 52 weeks multiplied by a week's pay, or £80,551, whichever is the lowest. This means that the method for calculating a week's pay is critical for those claimants who earn less than £80,541 per annum. So what a claimant would tend to try to do is to make sure that they get everything within that week's pay. So to effectively increase what their week's pay is. So would it include, for example, overnight stays? Would it include overtime? Does it include anything they could use to bump up that week's pay that you would normally find? So in what this case has done has got to the EAT to decide whether or not that week's pay includes pension contributions. So which ruled that it did. So the effect of this case is to increase the upper limit of a compensatory award when the employer pays pension contributions to a pension fund for an employee, subject to the £80,541. So as I've said, this approach does depart from the long established practice of excluding employer pension contributions when calculating a week's pay. So what does this mean for you? So really, the court's decision, as I've said, increases the maximum unfair dismissal compensation for all claimants who earn less than £80,541. So just to drill down on that, so say, for example, before it was just 52 weeks, and that would be gross pay. That's what normally people thought that it was, and it wouldn't include pension contributions. So say if you earn 30 grand a year, that's what your maximum that you could be awarded at the employment tribunal. With regardless of whatever the week's pay included, the maximum would be the 30 grand that you earned, because it wasn't the upper limit, it was the lower limit, which would be the lowest amount, which would be 30 grand. So that would be based on your 52 weeks pay. So someone who's earning 100 grand a year would get the £80,541, and they wouldn't have to work out the 52 weeks pay. So it's very significant for people who earn less than £80,000. So what this is, the effect of this is basically to push up anyone's unfair dismissal compensation, obviously if they're successful, beyond their 52 weeks gross, their gross annual salary, which is the 52 weeks pay, to include pension contributions up to £80,000. So potentially, if you had, for example, a teacher who was maybe at an age, say 45, 50, who still wanted to work for the next 20 years, but was unlikely maybe to get another pension, or for some reason couldn't get another pension, and so they are unable to work again for whatever reason, and you're looking at a career loss, and the pension contributions could be huge. So this has a significant effect on public bodies, including schools, where the employer pays very high contribution rates. It also has far-reaching effects as it extends to other UK remedies, such as compensation for failure to inform and consult on the transfer of a business, and the protective award for failure to inform and consult and large-scale collective redundancy dismissals. So basically anywhere in the legislation which refers to a week's pay as the calculating factor of compensation will now increase because of this judgment. So as I said, because of schools pay such high pension contributions, the effect of this judgment is particularly pronounced.
And so just to pick up on that point, so what we're talking there about informing and consulting on the transfer of the business, so thinking about TUPE, we're also there thinking about consultation in terms of redundancy processes. Again, be making use of SPS and speaking to our HR consultants or your designated HR consultant. Always happy to provide you with advice and support on these issues. So do make sure that you use us and use us wisely. Let me just check in with time. I make it 22. We normally look for these sessions to be around sort of 45 minutes up to an hour, appreciating sort of queries and questions that might come our way. The last thing that we want to talk about, Zena wants to share with us, is a really interesting case that relates to Ofsted and Ofsted inspection. So let's just take a little bit of time to look at that, and then we'll bring this session to a close. So thank you, Zena. Let's have a look at Ofsted.
Okay, yeah, so I thought we may have enough of employment law there, so I thought we'd dip our toes in and have a look at some education law. So there's been a very interesting recent case, which you, again, may have had emails about on any subscriptions that you've got for different education law sites, but the Durham Academy Trust brought a claim against Ofsted recently following a Section 5 inspection of the academy in late 2016. Ofsted judged the academy to be inadequate and placed it in special measures. So what Durham wasn't happy about this, which I kind of have personal experience of a lot of my clients not being happy about their Ofsted inspections and wishing that they could be challenged. And sometimes my client, that has happened, and schools have challenged them. But Durham has done what no other school has managed to do before. So they brought two claims against Ofsted. So the first claim was, well, this was also, I must say, in the realms of judicial review. So this is a public law case in the High Court. So the first claim that they made was Durham disputed the inspection outcome given by Ofsted, asserting that the judgment itself was unreasonable and so strikingly at odds with how the school performs that it was unlawful. So this is a public law argument that basically refers to what we call Wednesday unreasonableness, which is quite difficult to prove in the public law sense. So you're basically saying that a judgment is so outrageous that no one could have possibly have made that judgment if they were standing in their Ofsted shoes. So the other claim that they made, so it was a two-prong attack, and the other claim that they asserted was that Durrant also challenged the fairness of the Ofsted complaints procedure, specifically that the internal moderation process undertaken by Ofsted when a school is deemed to be inadequate ought to be capable of substantive challenge. So this line of argument picked up on the fact that step 2, I'm not ignoring the first claim at the moment about the unlawfulness of the inspection outcome. What we're really focusing on here is Ofsted's complaints procedure and whether their complaints procedure was fair. So this line of argument picked up on the fact that step 2 of the Ofsted's current complaints procedure states, and if you've ever complained to Ofsted before, then you'll be aware of this. So it states, if your complaint is about the inspection of a school that was judged to have serious weaknesses or to require special measures, the judgments made will not be reconsidered under step 2 of this policy. This is because all such judgments are subject to extended quality assurance procedures. So Durrant argued that a result of this approach taken by Ofsted in its complaints procedure, it never had an effective chance to change the outcome of the inspection using Ofsted's internal procedure. So effectively, if you look at that and you think about that statement of Ofsted's complaints procedure, they're effectively saying, look, we are so good at what we do, and our quality, we may make this judgment, but don't worry, it's put through extended quality assurance procedures where other Ofsted officers will look at it, and we're so great at what we do that don't worry, it will always be the correct judgment in the end. So we're never going to change our judgment because our quality procedures don't require us to, because they're so effective. So the judge accepted Durrant's position in relation to the complaints process. He concluded that a complaints process which basically implies that the decision makers' processes are always effective and therefore impeachable, thereby preventing an aggrieved party from pursuing a substantive challenge, is not a rational or fair process. The judge ruled that the report should be quashed on this basis alone. So Durrant didn't even need to look at the more challenging argument that they raised about whether or not Ofsted were correct in their judgment, as in, was the school inadequate or not. The judge was simply persuaded that Ofsted's complaints procedure was so fundamentally flawed that the report shouldn't stand on that basis alone, because they've challenged it, but there's no acceptable remedy through the complaints procedure. So the reports would be quashed because Ofsted's complaints procedure is so poor. So only weeks before this hearing as well, the TES reported that no school has managed to change or squash an inspection report following a legal challenge in the last 3 years. So what Durrant managed to do is impressive, but it did cost them a huge amount of money. So that's why a lot of schools don't go through the process, of a full challenge in the High Court because you are looking at hundreds and hundreds of thousands of pounds. So the first point to note is that the decision does not automatically, so I've touched on this before, so the first point to note is the decision does not automatically mean that the inadequate grade 4 judgment that Durrant got from Ofsted is now wrong. That still stands. There may be evidence they can rely on to support the judgment, that to show that the judgment was unfair or unlawful in line with the framework, and the school, but the school don't need to do that now. So, but that's an important takeaway for you, that this decision doesn't mean that just because Ofsted have made a decision about somewhere being adequate that it isn't inadequate. So, however, if a school is now or very recently been graded inadequate by Ofsted and you don't agree with the judgment, then to the extent that Ofsted has not amended its complaints procedure already in light of the Durrant decision, or successfully appealed the decision, which it may yet do, hasn't done yet, the school will have extremely strong grounds to challenge the fairness of the process on this point alone. So, in accordance with the Education Adoption Act, which came into force last year, an inadequate Ofsted grade now results in the Secretary of State issuing an academy order automatically. So, in terms of the academy order, and obviously if you're put into special measure, you're getting an inadequate judgment, then the academy order kicks in. But until Ofsted amends its complaints procedure or successfully challenges the High Court's decision, any inadequate judgment may be called into question and could leave the Secretary of State vulnerable to challenge if she attempted to force the school through the academy conversion, if the school was seeking to redress its Ofsted inspection via the complaints procedure. So that's another thing to be aware of, that if that's quite significant, that if it is going to put you at a school at risk of an academy conversion order, then it really may be worth challenging that judgment on this ground alone of the complaints procedure being unlawful.
Yeah, so interesting, and certainly if you find yourself in that position, Zena and her team are ready and willing and able to support you with exploring those sorts of cases. Just noting time, I make it 2:51, so there is just time for us to talk to you about some things that are coming up in the future. So let's have a quick look at future webinars. So November, we're going to look at the positive use of social media, and to do that we're joined by Rebecca Avery, an education safeguarding advisor. She's going to talk to us about that. December, we'll look at return to work interviews and look at best practice around that. Certainly it forms a key part of effective absence management, so we'll give you advice and guidance on that and realising those benefits. Invicta Law will be joining us again in February, so that's great, and we'll look to see what more insights they can share with us then. They also join us again in April. So whilst we look to keep our programme fairly responsive to hot topics of the day. So as you'll see, we've sort of publicised what we're covering for this term. We have already confirmed online the February and April events and Invicta Law's involvement. So if you're wanting to sign up for those, then please do so. You can do that already. Something else you might like to look out for is our SPS newsletter, because we're going to have a new feature in there and continue this partnership with Invicta Law, and we'll be having a new feature, Your Legal Questions Answered. So you'll be invited to share your questions, share your legal questions, and each month we'll take the 3 most popular questions, most popular themes, and Zena and her team will be having a look at those for us and responding to those questions in the following issue, the following newsletter. You'll hear more information about that this month, so in October's newsletter, and we hope that that is a feature that you find really useful and that you get on board, you share with us your questions, and we can keep these sorts of discussions going throughout the year. So I guess all that's left for me to say as we fast approach the sort of hour's deadline is to say thank you very much to Zena.
Thank you for having me. Thanks for listening.
And to thank you for joining us as ever. I hope it's been really useful. You'll have the usual evaluation form. Always love your thoughts and feedback, and looking forward to next month, folks. See you soon and have a great rest of the week. You take care. Bye.